Good morning. And yet another important judgment citation ratio dealt by Supreme Court, which you must know because these sort of cases would knock your door of your advocate office. And particularly students should also know the ex post facto laws, Article 22, Article 14 and 16, because the departmental selection process is being manipulated from time to time by every state authority is politically motivated. So this is the case where AIR 2026 Supreme Court 426. Here what had happened, they have started written examinations and selections advertisement was given, written examination held, provisional merit list was published. After recruitment process had substantially concluded, State of Bihar Engineering Service Class 2 Recruitment Amendment Rules 2022, which is constitutional rules being framed under Article 309, retrospectively introducing Rule 85, granting weightage for contractual experience and age relaxation from 2019. That was challenged before the High Court. The High Court has held that state government has power to amend the rules. But the Supreme Court says you cannot amend the rules retrospectively by referring earlier judgment wherein they held that you cannot select candidate once the game is started. Before starting game, recruitment process being held, and when games were started, you cannot bring new rules. So this is what they held, that retrospective application of advertisement against the advertisement date, application of Rule 85, impermissibility changed the basis of selection after game had begun, could not be applied to ongoing recruitment because it is violative of Article 14 and 16. Order of High Court was set aside and the state was directed to finalize appointment strictly in accordance with unamended Rule 2019 within 2 months. This is what the courts have held. Then see important portions I must share with you. The distinction drawn by respondents regarding the provisional nature of merit list is untenable. They say the list was provisional subject to verification of documents, not to subject to fundamental change in the criteria for placement in the merit list. That was the difference they have held. Then they say while the state undoubtedly has the power to amend rules under the provision of Article 309 of Constitution, this power is not unbridled. The power of respective legislation cannot be exercised to take away vested rights or to arbitrarily disturb a selection process that has been already resulted in the identification of successful candidates by publication of provision of merit list. This is what they say. This case, Sankarasan Das vs. Union of India, they have held a similar thing. Then they say the finding of the High Court that the amendment was merely a policy decision and could be applied retrospectively to the selection process in vague is completely erroneous. Even assuming that 2020 amendment rules are policy decision of state, they cannot implement in a manner that violative fundamental right to equality guaranteed under Constitution of India. This is what they say. So finally they have set aside the judgment. I hope you understand. Go through this judgment. Try to understand the reading out principle of the Supreme Court, the articles 309, the amended power. 309 rules are being framed is called constitutional rules to govern the services of state and central government employees. I hope you understand. Best wishes.